video cast that covers consumer-related issues, mostly in the class action space, mitigation of damages related to those issues. I'm Christine Argentine. I'm attorney at Cypher Shaw in our Chicago office.
And my name's Paul Yovanik, and I'm an attorney in the Chicago office as well.
Okay, and today we're covering the Colorado Privacy Act, right, and some recent amendments to that?
Yeah, so there was a recent amendment that went into place January 1st of this year, July 1st of this year, and, I think, regarding biometric information in Colorado. So to kind of step back a little bit, Colorado Privacy Act was enacted in 2021, signed into law, and then it went into effect July 1, 2023. And that was more of just like kind of like the more general privacy acts that we've seen. It was the third one to come into play after California and Virginia.
Okay.
And then it was Colorado. But then we fast forward to May of 2024, and the governor signs a bill, the Senate, to include biometric identifiers and biometric data to the Colorado Privacy Act. And that went into place July 1st of this year.
Okay. And is that around the same time? I mean, obviously Illinois, we've talked about Illinois' Biometric Act. That's been in place for a long time.
Yes.
But I know other states have been also kind of incorporating biometric information into their privacy statutes. Is that around this time? Where does Colorado fall on that?
Yeah, it falls right around the same time. Obviously a lot of states have tried to include either their own standalone Biometric Privacy Act, a lot of them trying to mirror what we have in Illinois, and then other states trying to add a little bit of a twist on it, and I think that Colorado does that a little bit. There's, and we've talked about this with the Illinois Biometric Information Privacy Act, but there was a lot to be desired once we started seeing this being litigated with, in the employment context with timekeeping, time clock cases. There's just a lot of, was it intended to go after companies using thumb scan time clocks, or was this designed for something different? Obviously when we talked about BIPA previously and how it was, came about in Illinois, it wasn't related to time clock cases. It was more of a bankruptcy of a company that was collecting biometric information and then put that information up as assets during bankruptcy proceedings. So
does the Colorado statute give a little bit more specificity in terms of why it was enacted?
Well, it doesn't give the specificity of why necessarily, but it gives a little bit more of a little bit more guidance in the employment context and also the consumer context. The one thing we don't see, for example, in Illinois Biometric Information Privacy Act is whether or not you can force someone to adopt and sign the consent as a condition of employment. Here in Colorado, you can. So there was just kind of these initial threshold issues of where is this applicable? Obviously, because this biometric privacy amendment in Colorado is something that went into effect this year, we know that we're not dealing with, again, we talked about it previously, old statutes, new technology. We're dealing with,
right.
This is very much with employment, time clocks, everything in mind here of how can we help guide this. It doesn't mean that you can just collect biometric information without doing nothing. You still have to get notice, consent. You have to have the policy in place. There's information that is required under the statute. The interesting thing is, so under the Colorado Privacy Act, there are the definitions of biometric identifier and biometric data. And under biometric identifier, it's a lot of what we see under Illinois BIPA, so fingerprints, facial recognition, iris, retina, voice print. But with biometric data, it's actually, it broadens it because it's defined as one or more biometric identifier that are used or intended to be used for identification or maybe combined with other personal data. So
to identify that person.
Yes.
Okay.
So we don't see that in, for example, Illinois' Biometric Privacy Act, but we're seeing that here is like it's almost like even if you weren't capturing it for one purpose, but it can be used in conjunction with something else, maybe you need to be concerned about it. So, obviously the issue that we're running into too is because this went into effect July 1st, we haven't really seen this play out from, an exposure standpoint. And, the difference between Illinois' biometric privacy statute and this amendment here in Colorado, there's no private right of action in Colorado. like there is in Illinois, which has made it just a hotbed for biometric privacy litigation. So, when we're talking to clients, when we're talking to people about these amendments, the questions always become like, all right, so what does this mean? So we look at other states. Washington, Texas have standalone biometric privacy acts. They don't have private rights of action.
Right.
We don't see a whole lot in Washington. We, for the longest time, never really saw anything in Texas. When we did see it in Texas, we saw the AG's office going against big tech using, facial recognition and kind of gathering consumer data for no real legitimate, or I'm not gonna say legitimate, but more of a purpose, as opposed to time clocks and timekeeping. We just don't know what Colorado's going to do here.
So Colorado AG has the power to enforce.
Correct.
Are there certain civil penalties that are in place for that?
There's not. There's more of just a notification that can go out, and then so again, it's just unclear of the steps of what happens after a notification. There's a reporting process that can happen for someone who wants to complain to the AG's office, and then it really goes from there. Obviously, we haven't seen what that looks like, taking it steps further. And so, why I think, it's important to talk about this amendment is, while it's not a private right of action, so you don't have to worry about the reckless or intentional violations, the negligent violations like we see here in Illinois and other states that have private rights of action for privacy statutes. This idea that biometric information combined with other personal data could fall into it, it's to be mindful that you might be doing something right in 49 other states and it might not, but now all of a sudden in Colorado they're expanding this definition of biometric data to include information that isn't biometric in nature, but when combined with something with a biometric identifier is now biometric data.
Right. And it's interesting because, I think we are seeing more and more kind of this patchwork of state legislation, enforcement in the privacy space, right? BIPA and the privacy space generally. We see it in TCPA with telemarketing laws, state by state, different requirements that are stricter than the TCPA or not. I mean, and I think, with even other areas of litigation, trade secrets, non-competes, you've got this patchwork. And so for companies that are national in scope, how do we counsel them on how to comply with privacy statutes like this?
Yeah, so I mean, for the longest time, an easier one was always to, all right, where is the statute that is the broadest and has largest exposure? When we talk about biometric privacy, largest exposure was here in Illinois, but now broadest in language, we start looking at statutes like this amendment in Colorado. It's like, okay, so how do we make both of those work? We have a lot of clients, but a lot of businesses do not want to have different consent forms for different states. We deal with clients who have employees that go across state at times, whether it's in logistics companies or or otherwise, and so that's always kind of that difficulty. And so again, having to adapt, which we will, of how do we counsel these clients on, okay, now we see, it wasn't, with biometric privacy, like I said, basically for compliance purposes, it was always, all right, let's focus on what Illinois requires, and then it generally is captured other state statutes that don't have the private right of action. But we were always really concerned, as we know, with the $228 million judgment that came after jury trial here in BIPA in Illinois. I mean, obviously that's where a lot of clients are saying, okay, well, I want to be compliant with this, but I can't have 40, 30, 20, whatever it might be, consent forms, policies. I need to have it because I also have an IT group that needs to understand how do we just stay compliant as a whole, and so that it does get very tricky. And so luckily there's a lot of things similar to Illinois as opposed, that we're seeing, like with the notice requirements, so a clear and accessible notice. I mean, that's similar to BIPA's requirements under publicly available policy. Consent requirements, so there's language in the statute that provides for consumers are required to consent for the disclosure, sale, retention of biometric identifiers. Employees need to consent for the collection and processing unless tied to job duties or background checks. So again, that's kind of like, when we're thinking about this amendment coming in 2025 here, it was clearly with the mind of, okay, employers use this, use these technologies for background checks, for legitimate business purposes, not to sell it, not to do anything that they shouldn't be doing with it, but for legitimate purposes. And so that is one thing that Colorado, I think, got right here. But then again, when it was a statute that was signed in, or it was an amendment that was signed into law just this year, I mean, we do have the benefit of current technology, current law applying it. So,
but I think, and we've talked about this a lot in terms of, privacy risk, and technology, and knowing what your technology is doing, is capable of, is collecting, and what's happening with that data, right? I mean, I think with Colorado here, with that kind of more expansive definition of what could be a biometric identifier, right? Now you have to know even more about what is that technology doing and how is it collecting?
Yeah, how is it collecting? And you start having to think further down the line of, okay, so we're collecting this information, but we're also collecting this information. Is there any point where this data and this information come together? Because now we need to know. It might not be one step; it could be 3-4 steps down the road. I mean, statutes kind of implying that could be biometric data as a whole. And so, going back to kind of requirements, we have obviously the restrictions of sale and purchasing of biometric information, just like we see in a lot of other state biometric statutes. Retention, deletion, same idea. Where we see kind of like these service access protections, businesses cannot deny services or charge more if a consumer refuses to consent to biometric data collection.
Okay.
So it's not here, sign this, and if no, then I'm going to charge you more because I need to. No, like that they are protecting consumers where if you don't want to consent to your biometric information being collected, that's too bad. That's too bad on the business.
Right.
Consumers are protected, and that's what, again, having a current statute and amendment to protect consumers of current technologies is doing.
Right. That's interesting. What else do we need to know about this statute, or do our clients need to be on the lookout for?
Yeah, so again, as I mentioned earlier, this statute has made clear that it can be, the capture and collection of biometric information can be a condition of employment. And so, I mean, that's critical here because we've had clients in the past worried about workforce, what do we do if we force this on them later, or what do we need, here it's clear, they don't have to worry about any type of retaliation or any type of other issues that come of this. And so what we do is, consumers, what to be mindful too is that consumers can request categories of biometric data collected to know what exactly is being collected, the source of the data, the purpose of the collection, and any third-party disclosures.
Okay.
Again, that goes back to just, with a lot of our privacy statutes that we talk about, transparency is key. And so when you are informing a consumer or employee of what's being captured and collected, that's what the courts, that's what an AG is going to be wanting to know. Do these people know what is being captured and collected? Because if they don't, that is what these statutes are designed to protect against. Now do they get abused, these statutes? Yes, they do, of course. There's a lot of gotcha type statutes out there, especially with some of those older statutes that we've talked about previously. But the real focus is transparency. So I think, kind of on that, what do our, clients or our viewers need to know? A big part of it is just understanding this statute and understanding that, leaning more towards transparency than not.
And it seems like record keeping, right?
Yes.
So if consumers have the right to request this information, and I think we've been seeing that right to request data information about what's being collected, captured, stored. We've seen our clients get requests for that more and more and more. And so keeping track of that information so you have it when that request comes in is probably key.
Yeah, and so I think, to your question, I think more kind of 4 points if I had to say, the first one for what we should be mindful of with this new amendment is, reevaluate your data classification. Again, some of the data that wasn't previously considered biometric data based on this broader definition could be. And so being mindful of that and flagging that of if this information reaches this information, this is now biometric data
Right.
too, because this biometric identifier over here has come together with it. So
Right.
that's something we need to be mindful of. Obviously updating privacy notices and consent mechanisms too, based on the requirements and based on what's being captured, collected, and why. Implement retention, deletion protocols, and that's similar to what we've always talked about with Illinois Biometric Information Privacy Act and other privacy statutes. And then, train internal teams, HR, IT, and legal to understand collectively, because it's kind of 3 points of the same issue. You've got your HR who's boots on the ground, and they're the ones, at least when you think about it like in an employment context, boots on the ground of collecting biometric information. IT's the one trying to figure out how do we keep this stuff housed. Legal's trying to figure out how do those two not violate the statute either.
Right,
so
right.
so that's where I think, and that applies even on the consumer side too, when businesses are consumer facing and they're collecting biometric information. I think, you got your local management, your local employees that might be using some sort of technology capturing biometric information. Then you also have your tech side. You have your legal trying to figure out that they're aware of how this information is coming together. Again, it goes back to reevaluating data classifications.
Yeah, that's interesting. So we'll obviously see as time goes on how aggressive Colorado's going to be in enforcing this.
Or very least what industries or what type of technologies they seem to go after. Like I said, with Texas going after big tech companies using, facial recognition for filters and kind of just for purposes and storing data of consumers. That was a big no-no under Attorney General Paxton.
Right.
And we kind of have a sense that what they're going after and what they're not. Colorado, still a little bit of an unknown quantity at this point.
Yeah. Well, time will tell.
Yeah, absolutely. Thank you.